Welcome back to the program. In studio, I'm going to call him famed defense attorney Tony Cotton. Tony, thank you for joining us. How are you?
I'm good. Thanks for having me on.
My pleasure. So I want to first ask you, what got you interested in law? And every lawyer I ask that has some fantastic story about how they were so moved by something they saw or something that they witnessed. Do you have a similar story?
So I don't know if I have the exact same story, but when I was a young kid growing up, my mom and dad got divorced when I was about 10 years old. And my mom had a high school education. She decided to go back to college. And so while I was in grade school, my mom went to college and then went to law school. So as a little kid, we would have in-service days where the teachers were basically getting, continuing education. And my mom would take me to UW-Madison. So I actually went to law school, so to speak, as a little kid and witnessed what it was like. The cool part about it was that my mom became a criminal defense attorney, which was something I didn't have any exposure to or familiarity with. But then,
which is probably good.
Yeah, it is good. Yeah. But then, as I went through high school, I saw my mom representing people who were in bad situations, and I really sort of fell in love with it.
As a defense attorney, boy, oh boy, do you see some very interesting things. And I know it's got to drive you up the wall when your clients, who has a constitutional right to your representation, and people need to know that, but when they find themselves in the clutches of law enforcement, and of course they're innocent until proven guilty, sometimes people do things that make it more difficult to defend them. So give us an example of something that's a pretty common practice that defendants do that can actually hurt their defense down the road.
So there's sort of two big things I see regularly. One is consenting or giving permission to law enforcement to search either a vehicle or a residence, or even worse, a cell phone in today's climate. Cell phones oftentimes have even more evidence of wrongdoing than either of the first two examples. The second thing I see is people confessing to the crimes that they're accused of. We see that regularly in our criminal cases where people are arrested, the police sit down, they bring them into an interrogation room, and the person ends up admitting that they committed the crime, which of course makes it very easy to prove that they're guilty once it goes to court.
A lot of folks don't know that police are trained to not just get the confession, but also even how they word. Well, you don't have anything to hide. You don't mind if I just take a look real quick. And most people being reasonable and logical, well, if I just let them search, then maybe I'll be on my way. Folks don't know that police are actually trained to be deceptive, because once you give consent to search, holy smokes, like anything they find, that's it, right? So maybe we talk about that for a little bit, that they're actually trained to be deceptive to get the confession and to get the consent, because that makes their jobs a whole lot easier.
Right. It makes the case almost a slam dunk in many circumstances. I mean, if the police find the drugs inside someone's house or in the car, or if the person admits to criminal behavior, it makes it fairly easy to prove the case.
Another thing that prosecutors, right? Are they your nemesis, or do you guys is there a level of respect? Because the prosecutor's trying to put your client away for 10,000 years plus 87 life sentences. Are they the adversary when you go into the courtroom, or do you have a mutual respect for what they're trying to do?
I'd say I have a mutual respect for what they're trying to do. It is an adversarial system, of course, where we're on one side, they're on the other. What I want to, I guess, draw a distinction here with is that it's not a personal thing. Even though they're adversaries, some of the worst things I see defense attorneys do is take things personally. That screws your client's case 9 times out of 10 when you are going to approach it as the prosecutor has a personal vendetta against my client, because it will shape how you look at the case. It will reduce your objectivity, and oftentimes it leads to worse results. So I would say you have to have a professional relationship, because, as you've probably talked about on this show before, most cases don't go to trial. Most cases, I think it's 97% of cases, are resolved by way of a plea or some sort of negotiation. So everything can't be nuclear warfare. There has to be dialogue. There has to be discussion. And especially in Milwaukee, there is an effort right now to really remove a lot of cases from the criminal justice system and move them more into a diversion territory. So certainly we want to have good relationships to help facilitate that.
Recently, we witnessed a trial, and it got a lot of attention. Theodore Edgecombe was the defendant. And first, let me ask this, because we had some confusion, because clearly none of us here are lawyers, or very few of us are. At least I play one on the radio, and I do a bad job of that. If you use a Your defense is self-defense, right? That is what you are maintaining, that you shot and killed someone in self-defense. Are you required to take the stand?
No.
You're not?
No.
Okay, so let's clear up that misconception.
Well, you're never required ever to testify. You could, in theory, advance a self-defense claim through witnesses that saw you act that way.
Okay.
You probably wouldn't be successful. I can't imagine a scenario where you would advance self-defense as the theory and not testify. But no, you don't have to. You're not required to.
I know you made some comments on social media about the Edgecombe trial. What went so miserably wrong, right? There was maybe a credible shot that maybe he was going to get off and the jury would find him not guilty because there was another high-profile case where that was the case. Another thing that we need to stop doing is we got to stop comparing one case where a defendant gets off to another case because we don't often appreciate the nuances in every single case. But what went so miserably wrong in the Edgecombe case from your perspective?
Edgecombe hired an out-of-state lawyer who was not familiar with how to try a case in Wisconsin and who had very little, if any, experience defending cases of that magnitude in trial. I don't know anything about the guy. I just know he graduated law school in 2019. And given the fact we had COVID shut down the courts for a year, I think the amount of experience he could have had personally, first chairing a homicide case, had to have been slim. And when I watched the trial, I could tell that he had no experience because the representation wasn't good.
I guess that pretty much sums it up. We can go into all the details we want, but I guess so he's facing 60 years, so there you go. Representation matters.
And it was a hard case. I mean, obviously it was not an easy case to win on self-defense grounds.
Speaking of self-defense, because, we've got a community that is awash in guns, and I'd imagine a fair percentage of some of your clients are also have firearms charges, I could imagine. True. How robust is Wisconsin's self-defense law? We have concealed carry now. There's a bunch of people who are too irresponsible to take care of a damn house plan, but they got a firearm and they feel like, I can use my gun to defend myself. It seems like self-defense law in Wisconsin, including Castle doctrine, and I'm not sure if we have this thing called stand your ground, but maybe we can talk about that. But how robust is self-defense law in the state of Wisconsin?
I was going to bring up Castle doctrine as an example because politicians in Wisconsin have been moving, at least in my 17 years of practice, more and more in the direction of giving people more of a right to use firearms to defend themselves. As you've probably talked about, CCW laws were passed, allowing people to carry a concealed weapon. They've talked about lowering the CCW age from 21 down to 18. Currently, you have to be 21 to have one. And our legislature passed the Castle Doctrine, which lets you use violent force in your home, deadly force in your home, even if a person isn't armed and attacking you. Regarding stand your ground laws, we don't have an exact statute like that in Wisconsin.
Is there this thing called duty to retreat? If there's some trouble afoot, and I recognize that there's trouble, not necessarily a threat, but it could be an imminent threat, do I have a duty to run away and to move away from the threat, or can I stand there and if somebody, does something threatening to me, if they're going to harm me or somebody I'm with, I can use my firearm?
Yes, you can stand your ground and you can use your firearm. But of course, look at what happened both with the Rittenhouse case which I was involved with for his co-defendant, and also what happened with Edgecombe's trial. The defense will be measured by the behavior of the defendant, meaning what you did is going to be studied under a microscope. So you can stand your ground and use deadly force, but you better be damn sure that if you're going to do that, I would say you better articulate that theory right away to the police and not do what Edgecombe did, for example, and flee the state and disappear and change your identity.
We are speaking with Tony Cotton, local defense attorney here. In fact, if lawyers get in trouble, I hear they call you Tony, so you must be one heck of a lawyer. It's almost like if I have a doctor, who was my doctor's doctor, right? Someone who was in the profession, who would they go and trust their outcomes to?
We won't name names today of who I've represented.
No, we probably won't. I'm sure some people would be very, very shocked. People don't realize this, Tony, that if you shoot somebody in total self-defense, like it's textbook, they drew a gun on you, they came into your house, and they were armed, all of the things that make a self-defense case literally airtight, which I'd imagine it's rare. People don't realize, you're still going to get arrested. They're still going to book you. They're still going to try and charge you with homicide, right? A lot of folks don't know that.
Yeah, usually that's true. And so that's why it's super important to have somebody on board that you can rely on or reach out to if that happens.
So I'm going to take a break. I want to come back, and I want you to, as best you can, go through the steps of what somebody should do, because so many people are unclear, especially in the black community, and we disproportionately interact with the criminal justice system, either as perpetrators or as victims. When somebody gets arrested, what should they do? We're talking to Tony Cotton. We're going to take a break, come back, and continue our conversation and listen to The Truth with Sherwin Hughes on the new 101.7 FM. Don't go anywhere. I'll be right back.
This is The Truth with Sherwin Hughes on 101.7 The Truth, The Truth app, and 1017thetruth.com.
Welcome back. We're in studio with defense attorney Tony Cotton. He's the lawyer's lawyer, is what he is. Tony, if somebody gets arrested, let's say for a felony, so not they're innocent until proven guilty, or so says the laws of this land, what is the first thing someone should do? They're being pulled over by the police. They know they're getting arrested. They know they're going to jail. What is the first step that potential defendant should be doing?
Key is to keep your mouth shut. Don't make your situation worse. And I would say right alongside with that is the absolute importance of not resisting, obstructing, or defying the commands that are given by law enforcement, both for your own personal safety because you could get shot and killed, but also because you don't want to make the situation worse. We actually have a felony now in Wisconsin. If a person injures a police officer, even just basic injury in the course of them being arrested, they can be charged with a felony. So it's a very serious crime, and it's something that you don't want to struggle with the police. They're going to arrest you. In all this nonsense you see on YouTube of people who are, being intentionally combative with the police. Please tell me the probable cause portions of the United States Constitution that authorizes this particular arrest. It's nonsense. The police officer is pulling you over. Challenge it in court. You're not going to win the challenge with the police officer at the scene of the stop. Shut your mouth. Don't give permission to search, and make sure you fight it in court.
When do you say, I want a lawyer? They say that in the movies, Tony. I need a lawyer. When do you say that?
It doesn't hurt to say it right away.
Okay.
I don't know that I would be rolling down my window shouting, I need a lawyer as the police officer pulls up. I suppose you could. I think typically what I tell people, what I often advise people is when a police officer is starting to ask you incriminating questions, so beyond providing your name, which you're required to do, once an officer starts asking you questions about crimes you might have been involved with or activities like that, then you should just say, I'm asking for a lawyer.
Right.
And, of course, you could also remain silent because you have the right to remain silent. You also have the right to counsel. So those are two separate constitutional rights you could invoke.
Now, when you say you want a lawyer, is it true that they immediately have to stop interrogating you?
So they do have to stop interrogating you. Whether they will is a different question.
Okay.
But once you've asked for a lawyer, the interrogation must stop. I think there's a misconception that once you ask for a lawyer, they have to provide you with a lawyer. That won't happen. 99% of the time, if you invoke your right to an attorney, if you say you want a lawyer, the police are simply going to end that interrogation. They're not going to open the phone book to let you make phone calls, and you're just sort of going to be on your own to figure this out.
Body cameras, how has that helped? Because as we were talking off air, before the interrogations weren't even recorded, it's just the cop and the defendant. The cop is just writing stuff down, and they would submit, whatever that police officer wrote down would be submitted to court. How have body cameras helped objectify the process?
It brings more truth to the case. It allows both the client to objectively see what happened. Many people who are arrested are in fact guilty, if not nearly all the people who are arrested have committed some crime. So it helps bring clarity to what took place. It helps, I would argue, make things more efficient in the criminal justice system because we don't spend needless time litigating fact patterns that we can clearly see one way or the other either happened or didn't happen. When I started practicing 17 years ago, we didn't even have audio recordings of our interrogations. When my clients were arrested, there would just be a written statement. The officer would write out what supposedly happened. Person may or may not sign it. And then that narrative would become the truth of what occurred, even if in the majority of the time, you'd have clients say, I didn't say it that way. That's not what I meant by that language. Those are his words, not mine. And then we were fighting that in court. The recording process has brought a lot of clarity to that. I think it keeps cops honest. I think most cops are probably honest at their core. This keeps cops honest. This also keeps defendants honest. So when we get cases and somebody tells me, hey, I didn't say any of these things, it sure helps to have a recording to either prove it or disprove it.
if you have a defendant that is now going to trial, you got another process that could be crucial to your defense, and that's this thing called jury selection. I know you can't give us all the details of what goes into that, but you as the defense attorney have the ability to strike certain jurors, and the prosecutor can do the exact same thing. If you had to give it like a percentage, how much does a jury selection weigh on the possibility of your client walking free? Do we put too much stock into actually the psychological profiles of jurors? Are they just regular, normal people, or do we want a certain type of person on that jury?
You want a diverse jury. The best results I get, and when I say you want, I mean as a defendant on trial, obviously, with the goal being to try to get an acquittal, you want typically a jury that resembles your peer group. As a general rule, when you are a black man, for example, who I've defended in Waukesha County, and you get 50 jurors brought in to choose from, 49 of them are white. And the judge will be white, and I'm white, and the prosecutor's white.
What do you do in that situation? Can you just file for a change of venue, or do you guys keep going through jurors?
I've had trials where the judge has permitted, because the law allows it, an entirely white jury to judge a black client. And the law.
How do they justify that as somebody's peer? Because we all know that that's not the case.
Right, because and I haven't read the case law before today's program with you, but in a nutshell, the law permits, as long as it's a group of people who claim to be unbiased, right? So certainly if somebody says, I'm racist, which they wouldn't say, right? But if somebody objectively appears to be biased, they can be struck from that jury pool and replaced with another person.
If they walk in with a Confederate flag hat, you can say, okay, you know what, this is a bridge too far. We're going to strike that one.
Right. So you do see... to your question of, what's the best jury pool, I don't think really we get into the psychology of each juror. I never have in my selection process. What I'm looking for is people who really can be fair. Because if I'm going to trial, I have a theory of defense that I know I can win with, and I just want the jurors to give my clients a fair shake. If I get a fair shake, I'm confident I'll win every time.
So you got a long trial, 2-week trial, 3-week trials, a lot of coverage, a sensational trial. Everybody's paying attention to it. Jury gets the case, then they go and deliberate. Jury, 2-week trial, 3-week trial. Everybody knows about it. Everybody's talking about it. High-profile trial. Jury comes back in 30 minutes, Tony. You nervous or you happy? Because we hear these myths like, if the jury needs another day or another 3 days to deliberate, that may mean one outcome is likely versus they go and they talk for 5 minutes and they come back.
The first trial I ever had was a guy who allegedly sold crack cocaine to an undercover officer. I was a brand new graduate right out of law school. I had no experience. I had never tried a case. I got this case from the public defender's office a week before trial. And there was an officer who testified that the man sitting next to me at table was the one who sold him crack cocaine. It was an eyewitness identification. They had the crack cocaine. They had the officer testify that he saw it in broad daylight. And jury went out. My client told me, swore he was innocent. And I raised all this doubt about cross-racial identification because this was a black male and he was wearing clothes that were similar to other men on 27th and Kilbourne. And we went through this whole trial, and I remember the jury came back in 17 minutes. And I called my stepdad, who's also a lawyer, and I said, oh my God, the jury just came back with a verdict. And he goes, remember to demand an appeal, because he was so certain a 17-minute verdict is guilty. And it was the opposite. It was a not guilty verdict. The guy walked on the case. And
they had the crack. The officer said that was the guy that sold him the crack.
Correct. 100% positive that was the guy. And the jury acquitted. They found him not guilty. This is a guy who 99% of the time probably would have been rammed into a guilty plea with a lot of people who would have just said this is hopeless. And I don't know if it was just naivety by me because I didn't know any better or because I believed my clients, but he wanted a trial. And so we gave it everything we got, and jury let him walk. And he was on bail for another crime. They found him not guilty of the bail jumping offense, which was because he's out on bail when he allegedly sold crack. So, of course, they found him not guilty of the bail jumping, too.
I see why people hire you. So, not that you need to go back and rehash that. I'm sure you have 1,000,001 times in your first case. But what do you think the jury heard, or what was the reasonable doubts in that case that returned the not guilty?
I think in that case it was just a question of really hammering, going back to your point about jury selection, making sure I had a group of jurors who could understand that mistaken identification happens. That when you have a white officer or a Hispanic officer identifying somebody of a different race, that not because we're intentionally racist, although some people certainly are, we can be mistaken. And we don't even realize we're mistaken. We think that that black person that we're identifying is the person who committed that crime. But, we were talking 27th and Kilbourne in the middle of the summer in broad daylight. I mean, I went over there and took photos in the middle of the trial. There was people everywhere. I mean, coming in and out of corner stores, guys that looked just like my client all over the place. And so that's how we all you need is reasonable doubt. You don't need to prove that you're innocent. All you need to do is show the jury that there is reasonable doubt. And if the jury agrees, they are required to find you not guilty.
Got another question for you about eyewitness testimony. I personally believe, and I got a reason for believing this, that we put way too much stock in eyewitness testimony. Eyewitness testimony is not always objective. It can be very subjective. And here's the example that I have. I was in a psychology class when I was an undergrad. And the teacher is just teaching. We didn't know we were a part of an experiment. That's the crazy thing about being in a psychology class. They're always experimenting on you when you don't know it, or these blind studies. And so the teacher is teaching and professing and doing whatever they're doing. A guy walks in, a student walks in. Oh, hey, I left this, my cassette player, my boombox in here. I was in the room an hour ago. Guy walks in, takes the boombox. We never thought anything of it.
Yep.
Teacher goes back to teaching. About 10 minutes later, the teacher just said, you just witnessed a theft, ladies and gentlemen. That person actually just stole that radio. I want each and every one of you to describe the person that walked in. Now, remember, we're focused on a professor. Most of us were probably distracted. A guy comes in who looks like a student, says, oh, I just forgot this in here from the previous class. It was amazing, Tony. Every single person, myself included, because then they had the person walk back. So we all wrote down our descriptions.
Yes, correct.
We had the person walk back in, and like maybe one or two people got like the shirt color right. I said mustache. He had a beard. One person said blonde hair. One person said he was dark skinned, of course. Eyewitness testimony is not really worth all that much, is it?
Here's the kicker. There's a study that was done right after 9/11 because everybody who's old enough remembers or thinks they remember where they were when 9/11 happened. And there was a study done right after that where a Yale professor had the class write out, where were you? Right now, days after 9/11, I want to know where you were, what you were wearing, what class you were in, et cetera. And when presented with the information 15 or 20 years later as to what the person said at the time, people believe that their current recollection is the truth, even when confronted with a different description they gave back then at the time after the event. So we almost become more confident in our own memory, and we lose any sense of objectiveness. So with your example, people will be confident that what I said originally is what that person looked like, and they will think that the person that's being brought in is actually a different suspect.
Isn't it a successful tactic, Tony? If someone is accused of a crime and they're arrested, and you delay. And you keep delaying. And because then over time, right, can't we then question someone's memory of the incident? Because I've seen R. Kelly was a perfect example.
Yeah.
The girl that was 14 years old, by the time they actually went to trial in Florida, she was 21. So 7 years had passed. It's almost like the entire narrative can change with time. So delaying is a good tactic, right?
Sometimes delaying can be a good tactic. I don't think that I can't think of many examples where I deliberately set out as that being the tactic. Delays are inevitable in the criminal justice system. There has to be a reason why you would want the case delayed. One of the worst things that I've seen lately is this rush by our legislature to pass laws that increase mandatory minimum sentences. Many of those statutes have sunset clauses where they expire at a certain time, and certainly, many of my clients would prefer to be sentenced once the mandatory minimum expires. So if you had a way to avoid that, you would. But I don't think it's a common tactic to just set out to delay. Typically what you're trying to do is identify the way to get the person justice and get them the best result without just pushing the cat down the road.
Tony, you got time for one more segment, about 10 more minutes?
Sure.
All right, we'll take a break, come back. I want to ask you about this thing called a retainer and why it's so important. We're listening to The Truth with Sherwin Hughes on the new 101.7 FM. My in-studio guest, defense attorney Tony Cotton. We will both be right back.
You are listening to The Truth with Sherwin Hughes on 101.7 The Truth, The Truth app, and 1017thetruth.com.
Welcome back to the program. Defense attorney Tony Cotton is in studio. He's available for a retainer. Maybe we should talk about retainer. A lot of folks may not know what a retainer is until they probably should have one, or when they find out it's too late. So just a quick synopsis of what having an attorney on retainer is.
A retainer is where a client deposits money with the attorney. They sign what's called a retainer agreement. We set forth an hourly rate that we will charge if our services are needed. We ask for a deposit, and then that money goes into our trust account, which means it is not my money. It sits in a trust account. It's a separate account. I don't tap into it or access it unless and until the client needs some services. So there might be people who, all different price points, who want to have a lawyer on retainer depending on the severity of what they expect to happen. And we'll take those retainers, we'll put it in our trust account, we'll sign a fee agreement, and then if nothing happens and the client needs the money back, then it's their money.
In a raid, this example you gave off air, somebody's got $90,000 in cash in the house, police raid, they confiscate all of that cash, right? That cash is gone. Wouldn't it be a smarter, like you said, yeah, you can keep $90,000 in your house. When you get raided, you then lose that $90,000. Aren't you better off before it becomes what we call a tainted asset? Because once you get busted and you got a whole bunch of other money that everybody knows is drug money, they may not allow you to use that drug money for your legal defense. But if you have cash, right, maybe you just give it to your lawyer and put it on retainer. That way it's not in the house.
It's certainly up to the client. I don't really make it my practice of random people just calling up and throwing money into my trust account. Typically, I meet with the person. I try to get a sense of what service they need, and then we quote a fee and we take the fees. I mean, we've seen cases of hundreds of thousands of dollars seized from people's houses or apartments along with drugs. And I can tell you 100% of the time, without exception, if your home is searched or your apartment is searched and you have cash in there, particularly a large amount of cash, that money is going to be seized, and you can go through the process of trying to get it back, which is a hell of a process to go through, trying to demonstrate that this is the proceeds of lawful activity and whatever other standards you got to demonstrate. It's incredibly difficult, and it would be more prudent for many people who think they may need the services of a lawyer to have retained a lawyer before the police have raided their place.
414-530 texts in with an interesting question. They say, in regards to probable cause determination, or PCD, what is it and how does it work?
So a probable cause is simply a legal standard, meaning that something is more likely than not. So there's different types of probable cause in the criminal justice system. Where we typically see it is when somebody has been arrested, there needs to be probable cause to continue holding that person, which means that a commissioner will review a case usually within 48 or 72 hours after an arrest to determine whether there's enough evidence to continue holding this person. If there isn't, the law requires them to release that person.
Tony, I just got a text message. I need him on retainer for my son. So if people want to learn more about you and the different types of law that you practice, and if they want to hire you for your services, how do they get in contact with you? Website, phone number? Sure.
So our website is www.kuchlercotton.com. It's Kuchler, cotton, COTTON.com. They could just Google my name, obviously. Phone number for the office is 262-542-4218. We've got offices in Waukesha, and we just bought a building in Wauwatosa not too long ago on the corner of 70th and North Avenue. So we're available for appointments as people care to schedule them.
You know, I knew we'd get a question like this. Mr. Matthews says, why are you advising drug dealers on how to protect their assets? Look, you're not a drug dealer until you're convicted of dealing drugs, right?
That's right.
So a lot of innocent people, here's the thing. People may have the misconception of, well, no, you want guilty people to go free. Isn't it your primary obligation, your fiduciary duty to make sure that anyone and everyone gets a fair trial?
Well, I want to make sure that people know their rights. And I want to make sure that with respect to that particular question, that people understand that if you just leave large amounts of cash sitting around, whether you're a drug dealer or not, if the police search your house or search your apartment and they find a significant quantity of cash, oftentimes it's going to be seized. So I don't particularly care what you do with it. My goal here is simply to make sure people understand you don't have to permit a search of your house. You don't have to permit a search of your vehicle. You don't have to permit a search of your cell phone. And I think that a fair process will unfold. The guilty will be convicted. The innocent will be freed when everybody plays by the rules, and that goes for both sides.
There was a Supreme Court ruling. There's been a few that really have an impact on modern-day law enforcement. Correct me if I'm wrong, Tony. The smell of marijuana is or is not a probable cause to search a person or a vehicle?
It is. It's considered probable cause, although there's very interesting challenges that are coming down the pipeline right now where that rule may change. But as of right now, if your car smells like weed, the cop can search it. And I think it's important to stress here, Sherwin, that if an officer is asking you for permission to search, they probably don't have probable cause. Otherwise, they would just be searching the vehicle, right?
That makes a lot of sense, I suppose. Well, you think it makes sense until somebody's actually in that situation. Is there another ruling? I don't want to cut you off, Tony, but there's another ruling that they can't hold you forever, right? There's a certain amount of time. They pull you over for whatever they pull you over for, because sometimes they would just make you sit, right? Your side of the road, traffic stop. There's a limit to the amount of time. Supreme Court, I believe, has ruled that they can't make you sit forever. A certain amount of time to effectuate the arrest.
Yeah,
if they're not going to arrest you, they got to let you go.
Yep.
Right?
So the amount of time that a person could be detained in a traffic stop has to be reasonable, and it has to be tied to the infraction that they were stopped for. Example would be this, Sherwin. So a person's pulled over for speeding. Car doesn't smell like weed, but let's say the cop just doesn't like the looks of the people, right? His radar's up. He thinks something's going on. He thinks maybe they've got drugs, maybe they've got money, maybe they've got guns. And that person was pulled over for speeding. There's no other evidence of wrongdoing, okay? The officer has to limit that stop to the amount of time necessary to complete issuing that ticket, and then they got to let the person go. They cannot continue holding you to bring a drug dog to the scene, to walk around the vehicle and sniff out the car. That case is a recent case. It's resulted in many pro-defendant suppression rulings, going to many defendants winning suppression motions because police will still sometimes expand the stop longer than permitted by law.
And the suppression motion is they kept me longer than necessary. They called the K-9 unit. It took them 20 minutes to get there. Dog comes, lo and behold, the dog, and I hear the dogs are junk science too, but the dog finds drugs, and you can then suppress whatever that dog finds because they violated the Constitution and how long they kept the person pulled over.
Right. So we've had drug dog cases where where you look at the dog records and the dog will hit, so to speak, hit on vehicles, and then when you dig into those reports, the dog didn't find drugs. So you know what the police will typically say when that happens? Well, there must have been drugs in the vehicle, so the dog is still reliable. He just must have been hitting on drugs that were now removed from the vehicle. So it's sort of like no matter what you argue, there's always a response for that. So we've been attacking drug dog cases vigorously. We get the training records, and we attack those head on.
So don't panic when they bring the drug dog, because guess what, ladies and gentlemen? I probably shouldn't say junk science, but maybe more like fake news. Mr. Tony Cotton, give people your telephone number and website if they're interested in your services.
Again, Tony Cotton, office number 262-542-4218. I do want to mention that if a person is facing asset forfeiture, meaning significant money was seized, probably the best person to contact would be Chris Donovan at 414-221-1950. Highly recommend him for those cases.
This was good, and I learned a lot, and got people texting in all sorts of things that we won't be able to get to today. But I'll tell you what, if you can find the time between representing your all innocent clients, maybe we'll have you back one day. Sound good?
I'll be here anytime you want me.
All right. Thank you guys for listening to The Truth with Sherwin Hughes. Stay tuned for the Tory Lowe Show. I'll see you guys tomorrow.